Okay, so good afternoon, ladies and gentlemen. I'd like to thank all of you, but especially my hosts, the Dean and the other panelists, my friend and colleague Adolfo Ciaretti, who invited me here and who organized today's event with the help of the sponsors and the assistants and the interpreters and everyone here. It's especially an honor for me to be here to see the publication of my book in Italian. There's a special pleasure that comes from having one's work read, but having one's work read in a different language is even more pleasurable. And of course, I thank the translator, Sylvia, for having done the work of translation, which is a major undertaking, as you know. Finally, I want to say before I begin that it's an enormous honor to be talking in a room, in an auditorium named for Guido Martinotto, who was just a wonderful sociologist and a wonderful colleague and a wonderful friend when he visited New York, as he many times did. So thank you for that too. Let me begin by saying a little bit about the origins and the ambition of this book. So, like most of you, I imagine, when I lived in Europe, as I did all of my life until 1997, I had no especial interest or knowledge or expertise in the death penalty. If I thought about the American death penalty at all, I guess I thought, as most people do, that there is a sign of America's punitiveness or racism or conservatism, but I didn't have a very deep understanding of its meaning. When I and my family moved to New York University in 1997 and became residents and eventually citizens there, there were many things about America that I didn't understand, many things that seemed strange and different. And I decided that I would try to learn about American politics, constitutional law, race relations, civilization, by studying in detail the death penalty as a kind of window onto the history and the contemporary politics and law of the USA. So, although the book foregrounds the death penalty, and that's what I'll talk to you about today, its real subject is America. And America as understood, partially understood, poorly understood perhaps, by a European who's moved there and who embraces its civilization for better and for worse. So I began to study the death penalty. And the first thing that I observed when I began to read the many articles and books and cases is how remarkably repetitive death penalty discourse is. That the literature on the death penalty goes around and round in circles, for and against, and says the same thing in lots of different ways repeatedly. Moral analysis by the philosophers, policy analysis by the criminologists, constitutional analysis by the lawyers. Over and over and over again, it's the same arguments, the same points of view, pro and con, for and against. So the first ambition I had in writing this book was to try to change the terms of the debate, to try and say something different, because otherwise, what's the point? Why bother with another book? In the book, I quote a journalist, and the journalist says something like, so much has been written and so much has been said about capital punishment that it seems vanity, it seems futility to say anything more. And he wrote this 200 years ago, in 1812. So it seemed to me that if enough had been said 200 years ago, too much has been said now. So my idea was, if I'm to write a book, it has to be a book that changes the way in which we discuss this issue. So let me explain how I tried to change the terms. First of all, I wanted to stop talking about the death penalty in a timeless, abstract, universal way. Whenever there's a debate about the death penalty, and especially whenever public opinion polls ask the public, what is your view? The question is always, do you support the death penalty or do you oppose the death penalty? But the death penalty does not exist in that abstract, timeless, single way. Only very specific, very practical forms of enacting and enforcing and imposing and executing the death penalty exist. And in fact, the American practice of enforcing and imposing and executing the death penalty is a very peculiar, very distinctive, unique system. I think we should ask the public in America, do you support a system of death penalties which does not touch 99% of all murderers, which when it is imposed in 66% of cases is overturned and reversed, when it costs millions of dollars, when it's imposed in a racially disparate way, when it takes on average 14 years between sentence and the execution of sentence, and ultimately when it's executed, it takes the form of a medical procedure that pretends to be mercy killing or euthanasia rather than a punishment. Do you support this penalty? That would be a good question. And it seemed to me it was important to present the death penalty as a practice, a specific set of facts and arrangements, not an abstract issue. The second thing I wanted to do was to present the death penalty as a state practice. It seems to me that the death penalty, always and everywhere, is a matter of the exercise of the power to punish by a state authority. And I know, and I knew enough to think that in America, the state takes a very distinctive and difficult form. Not the European style of state at all. The state is a contested and divided and pluralistic and co-possessed entity. Co-possessed in the sense of there is more democratic control, which today often means majorities plus millionaires, but there's more democratic control of state power in the USA than anywhere else. So my interest was in discussing the specific relationship between democracy and death in the USA. Third and final ambition for changing the terms of the debate. So, whenever the death penalty is discussed, it is inevitably and always in a normative sense. Are you for the death penalty or are you against the death penalty? Do you think the death penalty is moral or immoral, constitutional or unconstitutional? The question is always evaluative. I wanted to write about the death penalty in a way that was detached and dispassionate and sociological rather than moral. Many of my friends and colleagues, especially people who were Americans and who were engaged with the death penalty, viewed this as an immoral approach. They think it was wrong simply to write about such a morally important topic in an amoral, dispassionate way. I had a different view. My view was, when it comes to the American death penalty, the slogan one should use is res ipsa loquitur. Basically, the facts speak for themselves. That it's, I think, impossible when you know how the death penalty in the USA actually operates, actually functions, to offer any kind of moral, principled justification. It doesn't need David Garland, the individual, to say, I'm against the death penalty. It simply requires a detailed discussion of how the death penalty in the USA actually operates to make the moral point. And I thought it was made more powerfully on the basis of a presentation of the information rather than by wrapping this up in an outraged, subjective, moral position of one author amongst many. So these were the ambitions. Let me explain the arguments of the book. First of all, the descriptive analysis, and then the explanations that the book presents. The original title of the English language edition is Peculiar Institution, and both the Dean and also Professor Ciretti have mentioned this in their introductions. The plan, my idea was that this phrase, peculiar institution, has three distinct senses, three meanings. And if I describe each of these meanings to you, you will learn, I think, a lot about the nature of the capital punishment system today. The first meaning, the obvious one for many people, is peculiar institution in the sense of a comparative anomaly, a comparative unusual circumstance. I think maybe everyone in this room knows that elsewhere in the Western world, in the world of liberal democracy, the death penalty has been decisively abolished. The European Union and the Council of Europe regard abolition as a condition of membership. The International Criminal Court, which tries the worst possible cases of atrocities and crimes against humanity and mass killings, that court is not permitted the death penalty. Australia, New Zealand, Canada, South Africa, most of the Western world has abandoned the death penalty, and yet the USA continues. That fact is strange or peculiar, especially if you know the history, because in fact, many of the northern American states, many of the northern United States, Michigan, for example, Wisconsin, Rhode Island, Maine, these states abolished the death penalty almost a century before most European countries did. So, for example, Michigan abolished in 1846, Wisconsin in 1852. Britain, where I come from, didn't abolish until 1967, and finally in 1969. So, the idea of the USA being behind the reform curve, when it used to be ahead of the reform curve, was a surprising and paradoxical idea. The second meaning of peculiar institution has to do with the institutional design, has to do with the practice of carrying out the death penalty in America. And it seems to me that from a point of view of understanding the system, this is a very peculiar, very odd, very strange arrangement. Let me say what I mean. So, we say that America has the death penalty, but in fact, only 32 states have the death penalty in the federal government. 18 of the states are abolitionist. But within the states that have the death penalty, many of them never impose death sentences, or if they impose death sentences, they never execute anyone, or if they impose many death sentences like California, they keep most of the condemned individuals on death row forever. And the states that do impose and execute the death penalty are all in one place. They're all clustered in the southern states of the USA. Death sentences are very rare indeed. Today in the USA, tens of millions of people are sentenced to prison or jail every year. Tens of millions. Last year, there were 70 death sentences imposed. Now, this is in a country where there are 14,000 homicides a year, and yet of the 14,000 homicides, only 70 or 80 individuals are sentenced to death. But after these 70 or 80 unlucky or terrible murderers are sentenced to death, this is just the beginning of their story. Because in every death sentence case, when someone is sentenced to death, they will subsequently experience an average of 9 subsequent judicial appeals or reviews or habeas corpus hearings. The case will go from the trial court to a state appeal court, to the state Supreme Court, to the federal US Supreme Court, and then back again to begin another series of habeas appeals. And this process will take years and years and years. In the course of this process, something like 2/3 of all of the death sentences will be overturned. What I mean by that is that a court on appeal or on habeas petition, either a year or two later or 10 or 12 years later, will decide that the murderer was properly convicted but was improperly sentenced, that the death sentence was arbitrary or inappropriate, and so the individual will be resentenced and will be then a life prisoner, will spend the rest of his life in prison. The consequence is that most people sentenced to death actually are never executed. They die of natural causes in their old age in prison. After millions of dollars are spent and thousands of hours of lawyers' time and courts' time and appeals and hearings, work and rework the case over and over again. Now, remember, while all of this is going on, the murder victim's family is watching while their loved one's murderer is first sentenced to death and then reappears to question the sentence and then reappears again and again until eventually this murderer becomes the hero of the death penalty opposition, who are pointing out that he has been sentenced to death in a way that might be racist or in a way that might be arbitrary or in a way that might be unfair. And so if the family of the victim originally believed that they would get justice from the death penalty or even would get vengeance from the death penalty, after a few years they begin to think the opposite, which is that the death penalty is a never-ending, recurring, repeating sentence, which eventually will be overturned. And eventually the person will be sent to prison instead of sent to the execution chamber. The other thing that the death penalty practice produces is the conviction of the innocents. This is a photograph from many years ago when the first conference of exonerated death row inmates occurred in Chicago. And this is a process that now involves 140 men and a few women who have been exonerated from death row, people who have been sentenced to death and then discovered later to be innocent of the crime. A few of these cases, about 17 of these cases, involve DNA evidence, but most of them simply involve false confessions or false identifications or misconduct by the police or misconduct by the prosecution or else simple mistaken identity. But 140 people exonerated. The number of executions as a result is really small and becoming smaller. In the 1990s, the largest number of modern executions occurred. In 1999, there were almost 100 people put to death in that year. in 1999, there were probably about 21,000 homicides, but about 100 people were put to death for murder. Now the number is about 40 or 43 executions per year. And my expectation is that that number will continue to decline year by year into the future. One of the things that this points out is that something like 80% of all the executions that have occurred since the 1970s, when the modern system began, something like 80% have been in the southern states. Outside of the South, the only people who are put to death typically are what we call volunteers. Do you know what a volunteer is? A volunteer is someone who is sentenced to death and who decides to abandon their appeals. Someone who could, if he or she wanted to, continue to litigate and eventually to have their sentence overturned. Especially in the North, this is what normally happens. But people who volunteer, this is an example, Michael Ross Bruce, who was executed in Connecticut, something like 2008. And he insisted on having his death penalty carried out. The northern state of Connecticut was deeply embarrassed and deeply averse to carrying out the sentence. They'd never executed anyone. They'd sentenced people to death, but they had always avoided executions. Michael Ross insisted, after 18 years and many suicide attempts, on being put to death, and he actually caused the state governor to say how enormously difficult this had been. The state governor at first said, let's have 3 months to inquire into his mental health. No one could want to be killed. He must be suicidal, he must be depressed. Maybe we could avoid killing him by calling him mentally ill. The federal judge in the case said to his lawyers, said to Michael Ross's lawyers, if you abandon the appeals, I will have you fired. I will have you disbarred. We are not in this business to have our clients killed. Eventually, he was found sane. Eventually, he was executed. And the governor, who was supposed to be a pro-death penalty governor, Jodi Rell, she said, this is a sad day for the state that nobody wanted. Now, this, I suggest, is not how punishments are supposed to be. They're not supposed to be reluctant and hesitant and ambivalent and apologetic. If someone is a murderer, he killed 3 people, then presumably he deserves to be punished. The death penalty is a punishment that today even its advocates don't always want. Now this is a little different in the South. During the 3 months that Michael Ross was having his mental health studied, there were 15 executions in the southern states. So North and South are 2 different places. Finally, just to say that the average time now between being sentenced and being executed is 14 years. So one person has been killed after 26 years. In a few places, they're killed after 5 or 6 years, but the average time between sentencing and execution is 14 years. The final thing to note is that when the execution does ultimately occur, in the very few cases where it does, remember 14,000 homicides, 70 or 80 sentences, 40 executions after 14 years. The method of putting a person to death is, I would say, utterly disguised and embarrassed. Essentially, the idea is to pretend that this is a medical procedure in which the person experiences no pain, no bruising, no bleeding. In other words, it's a process that is intended to suggest the opposite of a punishment, that life is terminated, but without any pain, without any difficulty. Now, of course, this ignores, or this doesn't deal with the mental suffering of a person waiting for death for many years. But it's significant, I think, again, in telling us how reluctant and ambivalent and hesitant the American death penalty has become. It's also, I think, useful to remember that if this is how the death penalty is imposed in the USA, then the aims of criminal justice, aims like deterrence and retribution and victim satisfaction, are routinely failed, routinely not successful. Because most murderers would know that they'll never be put to death. Most retribution requires a swift, certain punishment, not a delayed, repeated, deferred punishment. And victim satisfaction is a cruel joke. Basically, the families of murder victims find the death penalty worse rather than better than imprisonment, which is today, the number of death sentences being reduced today, even in the South, primarily because victims' families tell the prosecutors they do not want the death sentence, not for that murder, not for their family. The third meaning, the final meaning of the term peculiar institution, is an American phrase, an American term, that was used by the 19th century slave owners in the South to describe and to justify slavery. They talked about our peculiar institution of slavery, which they regarded as being in some ways a protective, positive, morally justified, maybe even religiously justified institution. Peculiar institution is used of the death penalty because whenever anyone thinks of the US death penalty today, they think of a heritage of slavery and racism and racial violence and lynching. And the connection between today's death penalty and the history of blacks, especially blacks in the South, who were refused due process or legality, and who, if they were accused of a crime, would often be killed by a mob in a lynching. For many people today, the American death penalty is still a kind of legal lynching, still a kind of racist institution, still an institution that is shadowed and tainted by the racial heritage. There are many studies that continue to point to the racial disparities. Ever since the 1970s, the racism has become more subtle. It used to be that black defendants were more likely to be sentenced to death and executed. Now it's race of victim that is the pattern of discrimination. So if a black murderer has murdered a black victim, he is not liable to be sentenced to death. But if a black murderer has murdered a white victim, then it's much more likely. Now, some people, for example, Frank Zimring, who's a very important, very prominent criminologist, have pointed out that the same states that execute today, the southern states, are the states that lynched 100 years ago, and have suggested in a way that vigilantism or popular justice or self-help lynching is the explanation that connects lynching then and the death penalty now. Well, I have a problem with this sort of simple claim. It seems obvious that the form of today's death penalty, the way the death penalty is administered, is, if anything, the opposite of a lynching. Think about this, that no lynching ever takes 14 years to implement, never involves 9 stages of judicial appeal and review, is never carried out by state officials, is never carried out by lethal injection, so to be careful not to harm the person's body. This looks the opposite of a lynching. On the other hand, the social dynamics, the social circumstances that impose death sentences look very similar to the lynching scenario. Death sentences occur today primarily in southern counties where an interracial crime has sparked the passions and the anger and the fury of the local community, who demand not the usual punishment of prison, but the most serious punishment of death, and who are allowed to impose the death penalty by a government that insists on standing back and leaving it to the local people to decide their own conceptions of justice. These are the same social dynamics. So the form has become the opposite of lynching, very careful, very legal, very juridical, but the substance still connects to racism and to passionate communities and to a kind of mob justice that poor people and African American people in particular are the primary victims of. So, these basically are the descriptive analyses the book begins with, explaining how the death penalty looks today, how it's administered, how it compares with other countries, and how it connects with the racial and civil rights struggles of the past. The rest of the book tries to explain this phenomenon, to understand why it is that the US persists, why it is that the death penalty takes this strange form, and finally why it is that it continues to be racist in its imposition and in its pattern. So, let me come to the first question. Why does the death penalty persist in the USA and not in the other Western countries? Well, the first thing to observe is to remember it hardly exists at all in the USA, right? It's important, it's a big moral issue, a big political issue, but in terms of numbers, it's a tiny, marginal phenomena. Today there are 2.3 million people in prison or in jail today. 2.3 million. There are tens of millions of people who move through the system in and out of prison. In contrast, there will be 70 or 80 people sent to death row, and in 15 or 20 years' time, a few of them will be executed. This is a very small system. The truth is that America, just like Europe, used to have the death penalty and use it very extensively. Over time, it uses it less, reformed it more, restrained it, limited it, and eventually, in the case of the European countries, stopped using it altogether. In the USA, the country has gotten to the last stage, but not taken the final step. This is a penalty that has been really reduced and restrained and transformed, but hasn't quite been ended. So the question is not, why is the USA so very different from Europe or the West? The question is, why was the USA very similar to Europe and the West for most of the last 200 years, but at the very last stage hasn't abolished the death penalty? And the answer to this is, I think, quite simple. The reason that American states in the South continue to use the death penalty today is the same explanation for why American states in the North were able to abolish it 100 years before Europe did. And the answer is, In the USA, the power to punish is allocated to the local level of government. Decisions about criminal law, decisions about the enforcement of criminal law, and decisions about the penalties in criminal law are decisions for the states, not for the national government. And in fact, they're decisions for local counties, not for the national government. So that makes a huge difference. It means that the decision about the death penalty is not a national decision. It's a local, very local decision always. The second thing that's important is that criminal justice in the USA is not like criminal justice in Italy or in Britain or in most of Europe or in most of the West, because criminal justice decision makers are much more politically responsive, are elected rather than tenured civil servants, and they are in effect political actors. So the decision to charge someone with a capital crime is a discretionary decision, it's a choice. And that choice is made by an elected official, by a local politician called a district attorney. The sentence, the trial of a death penalty case will occur before a judge who is an elected judge. And prosecutors and judges who are soft on the death penalty will find themselves in southern states unelected and replaced by others who are firmer on the death penalty. Finally, the decision to impose a death penalty in the USA is made not by a judge, but by the jury. Now, what I mean by that, you should be careful to think of this. The jury does two things. The first thing is kind of normal. The jury decides, is this person guilty or innocent? That's a normal jury function in criminal law in states that have juries. But in America, in the death penalty, the jury makes a second decision. And that decision is, should this guilty offender be sentenced to death or not? And that decision is not made by law, is not made by the judge, but is made by the jury. 12 lay people deciding for the first time in their lives on a capital case about whether the person should live or die. Now, that level of political control and community involvement in criminal justice exists nowhere else. The only other place I've ever seen this system proposed is in Karl Marx's description of the Commune in Paris in 1870. There was the idea of electing, popular election of the police, of the judges, of the prosecutors. That seemed to most Europeans much more radical than was acceptable. In America, that's the system. The second reason why the death penalty persists in the USA is that in every other country where the death penalty has been abolished, it has been abolished by the national government once and for all for the whole nation. In the USA, it would have to be abolished by 50 different states, one after the other. Up until now, something like 25 of them have abolished. Some of them have reintroduced it. But there cannot be a national abolition because it's a state-by-state decision. The other important issue is that elsewhere, wherever the death penalty has been abolished, the national government, or sometimes a constitutional court, for example in Hungary or in South Africa, has taken a decision against the preferences of the majority of the people. So, for example, if you look at Germany in 1949, when the new constitution abolished the death penalty, 66% of Germans supported the death penalty. In France, when François Mitterrand abolished the death penalty in 1981. Something like 73% of French voters said that they supported the death penalty. In Canada, in Britain, 30 years after the death penalty was abolished, a majority of people still support it. In every case of abolition, a national government has ignored majority public sentiment and abolished the death penalty. Now, that can be done in America too, and in fact, in some states, that's exactly what has happened. In New Jersey recently, in New Mexico, in Illinois. But most of the time, it's very, very difficult for American politicians to take an unpopular stand on an issue that the public cares about. Why? For two reasons, maybe three. First of all, elections occur there every 2 years. The House of Representatives is re-elected every 2 years. Secondly, the parties are comparatively weak. Individual politicians gather their own funds, get their own supporters, run their own elections. The party provides very little cover. So individuals are running for office, not the party. Most importantly, we have primary elections. A primary election means that if I'm a Democrat or a Republican and I've taken an unpopular stand, then the next time there's an election, within my own party there will be a primary election. Someone else will say, I have all the same policies as Garland, except I also support the death penalty. He will get elected in the primary, and then he will get elected in the general. So it's very difficult in American politics to take unpopular counter-majoritarian stands, and not surprisingly, politicians mostly don't do so. So, all of you who are thinking ahead are saying to yourself, okay, but even if the local governments have control, even if the state and the Congress has a hard time making unpopular decisions, what about the Supreme Court? Isn't the Supreme Court the place where the American death penalty could be abolished once and for all? And that's exactly right. That's exactly the answer. In American political life, any statute, any practice which is a violation of the Constitution can be swept aside, can be invalidated by a decision of the Supreme Court. So, in a way, the last part of my book becomes really the story of how the Supreme Court has become involved in the death penalty, how it has changed the death penalty in very many important respects, but also why ultimately it has left the death penalty to the decision of the people. Up until the 1970s, every constitutional lawyer, actually up until the 1960s to be more precise, to 1963, every constitutional lawyer in America assumed that the death penalty, however bad it was, however immoral it was clearly in line with the Constitution. Because actually the Bill of Rights, the first set of amendments to the American Constitution, refers to the death penalty on 3 different occasions. So it was clear that the drafters of the Constitution assumed that the death penalty was acceptable. It's also true that in constitutional practice, death penalties were imposed for 200 years without any serious challenge to the death penalty by the constitutional courts. I think prior to 1963, there were 3 Supreme Court cases of any importance. And in each case, the Supreme Court said, yes, of course, the death penalty is constitutional. The first case was when New York introduced the electric chair, and there was a question, is the death by electrocution acceptable in constitutional law? And the Supreme Court said, yes, it's not a problem. The second case was in Utah, when the Utah introduced shooting, the firing squad, and the Supreme Court again said, yes, shooting is fine constitutionally. And the third case was when in Louisiana, Francis Lee was executed once and the execution failed. And so the question was, is it okay to execute someone a second time? And the Supreme Court again said, yes, that's fine. There was no constitutional question about the death penalty. However, in the 1930s, the 1920s and 30s, there were some cases of Southern justice that were so obviously and scandalously racist that involved torture, involved no assistance, no legal representation, involved all white juries sentencing to death black defendants who were, most people believed, not guilty. These were such terrible scandals that they were called legal lynchings. And the Supreme Court took cases and decided that tortured confessions should not be acceptable, that people facing a death sentence should have a lawyer, and finally that juries should not be all white. These were the first Supreme Court decisions on the death penalty. In the 1960s, the civil rights movement and the civil rights movement organizations that were challenging racism, segregation, the exclusion of blacks from voting and from election processes, the civil rights community decided that probably the death penalty in the South was a civil rights issue, because the death penalty in the South was used primarily against blacks and sometimes only against blacks. For example, there was the crime of capital rape. And capital rape was an offense that carried the death penalty. The only offenders ever charged with capital rape were black men charged with raping white women. And in many cases, these were actually consensual relationships that came to light and were so scandalous that the woman would claim she had been raped and the man would be sentenced to death and executed. For the civil rights movement, this seemed like a racist violation of the rights of African Americans. And so the same organization that had successfully challenged school segregation, the NAACP, the National Association for the Advancement of Color People, this organization decided to take up the racist death penalty. And the first set of death penalty cases that they brought to the court were, in every case, racist circumstances. Black defendants who were charged and sentenced to death for robbery or for rape or for murder in circumstances where no other white person would be sentenced to death. And remarkably, this court, the Furman Court, in 1972, decided that it was persuaded that the death penalty had become unconstitutional. It had become unconstitutional for two reasons. One is it was being administered in a way that was arbitrary and unguided and probably racist, and therefore was denying due process to capital defendants. And secondly, it decided that the American people had changed their moral standards, that there were evolving standards of decency, that more and more Americans believed the death penalty was wrong, more and more of the courts and the juries were refusing to impose the death sentence, and so the 8th Amendment to the Constitution, the one that says there's a prohibition on cruel and unusual punishments. Now the Eighth Amendment applied to the death penalty because the death penalty had become cruel and unusual. One of the justices said, to be sentenced to death today is like being struck by lightning. No one knows why it happened. There are no rules. The juries decide without any law. Suddenly a black person is being sentenced to death, but the person who committed the same crime in all the other courts is sentenced to prison. This is an arbitrary, illegal, unconstitutional arrangement. So Furman, in the 1972 case, declared by a 5-4 majority that the death sentence as administered then was unconstitutional. And overnight, all of the death rows in the USA were closed down. 600 men who'd been sentenced to death and a dozen women were released from death row, sent to the main prison system, or sometimes even after a while paroled and released. Well, the decision in Furman occurred in 1972. It was really the end point of a process of litigation and civil rights challenges and evidence about racism and legal argument about arbitrariness that began almost 10 years later in 1963. So the litigation begins in 1963, concludes in 1972. In that short time, America and American political life was utterly transformed. 1963 and 1964 was the high point of the civil rights movement. It was the high point of liberalism in the USA. It was the time when Lyndon Barnes Johnson, the Democratic president, was elected with a landslide and 61% of the popular vote. In 1966, most Americans, briefly, said that they did not support the death penalty. This was a very progressive liberal moment. By 1972, everything had changed. The civil rights movement had become more militant. Rosa Parks and Martin Luther King had been replaced by Malcolm X, and by the Black Panther movement. There was a reaction against civil rights by white ethnics who objected to desegregation, objected to busing in schools, objected to jobs for blacks that they themselves would claim. There were increases in crime, and especially increases in homicide, that were higher and faster than ever before in the history of America. There were riots in one city after another, the Chicago riots, the Watts riots, the Newark riots. And by 1972, Richard Nixon, the Republican president, had been elected twice, the second time in a landslide. And by 1976, he had appointed 4 new Supreme Court justices. So, how did the Supreme Court decision in Furman versus Georgia, how did it affect the American people and the American political system? The answer is that it created and mobilized the most powerful backlash, pro-death penalty movement that ever existed in the USA. In America today, in America in the 1970s, it's very difficult to pass a law, very difficult to enact a legal change. If anyone followed the affordable care efforts to improve health care in the USA, you will know what I mean. Nevertheless, in the 2 years after Furman versus Georgia was decided, 35 states passed new death penalty laws, immediately legislating a new capital punishment system. So the Supreme Court had a problem. It had abolished the death penalty as then administered, and now there were 35 new states, or 35 states, that had new statutes and were sentencing people to death once again under a new legal authority. I can do with that. The result was the Supreme Court decided it had to take a new case and examine whether the new statutes were constitutional. That case was Gregg versus Georgia. And in Gregg versus Georgia, the death penalty was framed as a very different issue. In the Furman years, every case was carefully chosen, so there was a black defendant who'd experienced racist justice. In the Gregg case in 1976, and the other cases taken by the court at the same time, all of the defendants were white. And all of the issues were presented as law and order issues, not as civil rights issues. So what the court decided was that the new death penalty statutes were indeed legal. So Gregg versus Georgia reestablished the death penalty. The Supreme Court became, in a way, the owner of the death penalty, because now the Supreme Court had set out the terms under which the death penalty could be used. I would suggest to you that in the 40 years since 1976 to the present, the Supreme Court has produced a death penalty system that exists, is occasionally used, but is completely unworkable. And the Supreme Court has done this for reasons that I think are intelligible, but which are, in a way, American and in a way pathological. So, to summarize what the Supreme Court has done, it has done two main things. The first thing is to try to impose law on the death penalty system. And imposing law has meant imposing appeals and reviews and restraints, with the consequence that the death penalty has become delayed and deferred and time-consuming and always reversed. This is the work of the Supreme Court. It's made it legal and at the same time unworkable. But after the experience of Furman, the Supreme Court decided that the question of death should always be left to the people. The question of death should always be a matter of democracy, not of elite legal decision. So, the death penalty is to be a matter not of the court's decision, but of the states and of the counties and of the elected district attorneys and of the community members of the jury and whatever they decide. Which, if you think about it, is precisely why the American death penalty has the form of an anti-lynching. It's basically overlaid with law and process and legal scrutiny and legal delay, but it has the substance still of a lynching, because the people who are enabled and empowered to impose it are once again the local community acting themselves in terms of popular justice as they see it. And that, I think, explains not just the relationship between the death penalty in law and practice, but the relationship in America between democracy and the law. Most people in Europe think that the anti-liberal forces, the forces that are against liberalism, are fascist or Nazi or Soviet communist, and they are the kind of forces that produce the death penalty. In America, democracy can be an anti-liberal force. And that's the biggest lesson and the biggest insight that I drew from my research. Thank you.